I think 10:15 this morning, but yes, it's always
Yes.
worth the wait. I don't mind waiting.
No, I wish to apologize to you on behalf of all of us because we took much longer with the previous candidate. So the time when you expected to be interviewed came while we were busy. And other candidates are also going to end up coming in later than they had planned. But we apologize.
It's not a problem, Chief Justice.
Yes. I also thank you for availing yourself for consideration for appointment as a judge of the KZN Division of the High Court. We appreciate the fact that you have made yourself available. I'm going to ask you certain questions, and when I'm done, I'll ask the AJP to ask you such questions as he might wish to ask you, and thereafter I will give the opportunity to the MEC who is here representing the Premier, MEC Mshengu, and thereafter other commissioners might have questions. But I do want to say that you will get very crisp questions from the commissioners. There will be no preambles. You'll just get crisp questions. So I would urge you to also give crisp answers.
Chief Justice, I think that time of the day and the week might maybe encourage everyone to be crisp.
Also, don't expect any other commissioner to greet you now, even if they know you have greeted. I've greeted you on behalf of all of them. Okay.
Thank you, Chief Justice.
All right. I see that in terms of academic qualifications, you hold a B.Juris degree and an LLB degree. Is that correct?
That's correct.
And you got these qualifications from University of Pretoria and University of South Africa.
Yes, that's correct.
Yes. The B.Juris was in 1991 and the LLB was in 1999.
That's correct, Chief Justice.
And you started your working life in the early 90s as an admin officer in the Department of Trade and Industry. Is that right?
That's correct.
And later on, you were appointed as a public prosecutor, and you worked as a public prosecutor from 1993 September to January 1999.
That's correct.
And in July 1999, you were admitted as an advocate and you joined the Society of Advocates of KwaZulu-Natal.
Yeah, I think I was admitted in either April or May of 99, but I started practice on the 1st of July at the Pietermaritzburg Bar.
Okay. And have you been practicing as an advocate since then up to now?
Yes, yes.
Yes, and that gives you how many years of practice?
Chief
About
Justice,
21?
It will be the 1st of July, coming 1st of July, it will be, I think, 23 years.
23 years.
Yeah, if my maths are correct.
Yes.
It's late in the day.
Yes. And when did you take silk?
I applied in April 2020 and my latest patent was signed on the 5th of May last year, 2021.
Oh, you only applied after you had done more than 20 years in practice, huh?
Yes, I applied for the first time in 2018. There were quite a few people at our bar that applied at the same time, a few of my contemporaries that started practice together with me. And because of it's quite a small bar, and at the end they decided to only award silk to 4 of the 8 or 9 applicants, and I wasn't one of those 4. And then I applied for the second time in 2020, and then I was awarded silk after that.
Yes. And tell me your practice, the cases that you have been doing over the years, to what branches of law do they relate?
Chief Justice, I've heard people describe it as a generalist practice. I've done a lot of family law. Obviously, when I started practicing, being a woman, you get briefed to do divorces and custody and those types of disputes, delictual matters, motor vehicle collisions. I've done a few fire cases. I enjoy doing fire cases. I've done commercial work. I've done work for banks. Basically everything that comes across my table that I get briefed to do. So I haven't specialized in anything specific, but I've done a wide variety of matters.
Have you done, have you had a lot of commercial law cases, commercial work?
Chief Justice, I wouldn't say it's a lot. I would probably estimate it's maybe 20 to 30% of my practice.
Yes.
It's difficult to put a figure. If you try and think back over the years what's been done, it's difficult to put a figure to it, but I've done, yes.
Yes, labor law work?
Labor law, not so much. In the beginning of my practice, I appeared in the CCMA in the labor court a few times, but that's not something that I pursued.
Yes.
I didn't enjoy it that much. I just
Administrative
got
law?
briefed in other matters.
Administrative law?
Not a lot. Not a lot.
Constitutional law?
I've not appeared in the Constitutional Court. Constitutional law matters, obviously in a lot of the cases I deal with constitutional issues, but it's nothing to do with having certain sections declared unconstitutional. That type of briefs didn't come across my desk. But if you appear for someone who's trying to, a parent who's maybe trying to take his child away from an abusive parent, the Constitution comes into play. So in that regard, it's not that the Constitution is unfamiliar with me or constitutional issues, but yes, I haven't appeared in the Constitutional Court.
And competition law?
Competition law, no. There's not much in Pietermaritzburg. It's a small bar, and I don't know if there's many practitioners, even in Pietermaritzburg or in Durban for that matter, that would have had much exposure to competition law. Seems to hang around the Gauteng area, Cape Town.
Or maybe there is no competition in KZN.
Maybe not. I don't know if that's a good or a bad thing.
Okay.
We all get along well there. We don't compete too much with each other.
And have you done a lot of delictual matters?
Oh, yes. No, definitely.
Yes.
Definitely.
Now, have you, how long have you acted in the High Court?
Chief Justice, if my calculations are correct...
Roughly, even if it's not accurate, precise, but roughly.
No, I've calculated it as 50 weeks. I think that's just under a year.
Yes.
I started, my first acting stint was November, December 2019, and then since then I've acted intermittently over the time. My last acting stint was now this last session before the recess.
Yes.
But I've done quite a few acting stints.
Yes. And during the time in practice, are there some cases that you have done that have ended up producing reported judgments?
Chief Justice...
Where you appeared as counsel, not which you...
Yes, I understand that. Obviously, I don't have control over who reports the cases, but there's one matter that was reported, I mentioned it in my form. I think it's either the Sabia matter or the Nyoko matter, if I can just have a look.
So there would be one or two, you say?
I think there's in the SA law reports, there's one, and then there's one or two others just in judgment online.
Yeah. And in terms of judgments you have written as an acting judge, Are there some judgments that have found their way into the law reports?
Only 2 at this stage, but
Yes.
hopefully more will come.
Yes. Okay. And how did you find acting when you started acting for the first time?
Chief Justice, I must say the first day I had to appear in motion court, or not appear, had to go and sit in motion court, I was quite nervous because you walk in there and you suddenly look onto practitioners that just a week before you were sitting next to them down there in motion court, and you know you're going to be judged by them. But as soon as it started, I just felt absolutely at home, and I actually now enjoy motion court quite a bit because it's a bit of an adrenaline rush on the one side, but it's also a way of interacting with counsel, and I've enjoyed motion court and acting overall. The first time I had to sit down and write the judgment, and I'd finished doing my research and knew I could now sit and start writing. It was an incredible feeling. That's where the magic happens. You start writing a judgment and everything comes into place, and you just know that this is what I want to do. And that for me was the job satisfaction factor was sky high. That's why I'm here today, because I'm enjoying doing that.
Yes. In terms of your practice, do you still do civil trials and criminal trials?
Chief Justice, because I've been acting intermittently over the last 2-3 years, I must say my practice has taken a little bit of a backseat because I've decided to focus my energies on acting and getting experience as an acting judge. I finished last year, I had a part heard as counsel that I finished during the recess periods and in the periods when I was not acting. That was my last trial that I did. It was a divorce matter that ran over about 2 or 3 sessions because it was quite a long, drawn-out matter. But I basically, at this stage, when I go back to chambers, I get briefed to do a few things here and there, but a lot of the attorneys know that I'm not available for long-term projects. So if there's something like a quick urgent application or going to court to oppose an urgent application, something to that, that's what I do at the moment. The long-term things like getting briefed for trials that's coming up is taking a bit of a backseat at the moment.
But previously you did civil trials and criminal trials.
Oh yes, no, I was in civil trial court continuously. I did a lot of civil trials. That was fighting in the trenches. That was my practice. It was about. I was in trial court very often.
Yeah. And you have sat in full bench appeals as an acting judge?
Yes, yes.
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 And done criminal trials as an acting judge as well?
I've spent about, I think, 13 weeks in criminal trials. I've completed 2 long criminal trials, and at the moment, well, we sat last week in the one I'm currently busy with. We finished all the evidence last week. It's been adjourned now for argument and for sentence. But I was 13 weeks in criminal trials. I've done a civil trial. I've been allocated from my notes 13 civil trials. Obviously, a lot of them got settled along the way, and we didn't end up in court, but one of them was a fire case that ran for a week. We were supposed to carry on with that case during the recess last week, but the party settled, so we didn't carry on with that. But yes, I've been in full bench special opposed motions, full bench criminal appeals and civil appeals. Yes.
And what is your understanding of the rule of law?
Well, Chief Justice, it's such a general term, and it's in the news so often, but it's basically everyone is subjected to the laws of the country, whether you're a state organ or an ordinary man on the street or a government official, we're all subject to the same laws of the country. And that underpins our democracy.
Mm-hmm. What is your understanding of the doctrine of separation of powers?
Well, we as judges try to not interfere in other spheres of spheres of government, either the legislator or the executive. But sometimes we don't have a choice. But yes, those powers are all. Everyone is supposed to stay in their lanes: the judiciary, the executive, and the legislator.
Mm-hmm. Do you know whether the model of the separation of powers that we have in South Africa is the same as in other countries, or it's got its own features in South Africa? Is that something you'd know or not?
Chief Justice, I have to think back very, very far to my university days to try and compare the situations in other countries. I would think ours is probably based on other countries as well, but we might be unique. I mean, there's a lot of things in South Africa that's unique. Our constitution is unique, and I wouldn't be surprised if that is also unique. But
And what can you tell us about the independence of the judiciary?
that is the most important thing of what we do. We have to be independent. We cannot pay attention to all the noise out there. We cannot let ourselves be intimidated by what people say in the press and newspapers. We cannot be swayed by or influenced by criticism out there. We've absolutely got to just put the blinkers on and focus on doing what we have to do and be independent in doing so. It's probably the most important thing of being a judge.
What can you tell the commissioners to show that you are somebody who embraces the values of the Constitution?
Chief Justice, I feel very strongly about the Constitution and about the rights of people. That's partly why I want to do this job, because someone in our position can make a difference every single day. Someone can come into court, maybe an unrepresented litigant can come into court who absolutely begs for an opportunity to make arrangements to not lose his house. There we can make a difference as a judge. A litigant can come into court, a woman whose husband is divorcing her and she lost her job, she cannot afford legal representation, and she just begs for an opportunity to approach a legal aid office. There we can make a contribution. But it's difficult to put it into words. It's just something I feel passionate about, and it's what judges have to do, is to pay attention and do their jobs with the Constitution in the back of their mind every single day they walk into court.
Yes. I'm now going to give the opportunity to the acting judge president to put questions to you. He and the MEC and the commissioners will put questions to you aimed at satisfying themselves how your appointment, if you were to be appointed, would meet the selection criteria that this commission has approved as the criteria that it uses in interviews. And those criteria include establishing whether you are duly qualified, whether you are competent technically, and whether you have capacity to show energy and motivation, and to show whether you would promote the values of the Constitution, and also to show, to ask the question whether what message your appointment would send out to the community at large if you were to be appointed. And the Constitution does require that when this body considers the filling of judicial positions, it should consider the demographics. So they will ask you questions that are aimed at satisfying themselves about that. So I will now give the opportunity to the acting judge president. I just point out AJP because you were not here when I pointed this out in the morning, that due to time constraints, the commissioners have restricted themselves to 2 questions, and I'm probably going to restrict them to even 1 this afternoon. And, but I do give the head of court more leeway to ask more questions, because the head of court knows the needs of the division. So I'll give you a little bit more leeway. You may start.
Thank you, Chief Justice. Good afternoon, Ms. President Wood.
Good afternoon, Acting Judge President.
How are you feeling today?
I'm feeling good, as can expect it. It's long in the day, late in the day.
Okay. During your acting stints, did you encounter any problem? If the answer yes, what problem it was, and how did you resolve it?
Acting Judge President, I didn't really encounter any problems in doing the work. The only problems I encountered were technical problems, such as maybe recording machines in court not working and having to reconstruct proceedings. But other than that, I haven't encountered any problems.
Okay. So is there any area of law where you feel that you still need an exposure?
Acting Judge President, it's difficult to answer that, because over the last 3, almost 4 years, I've been given a wide variety of cases, and some of them were completely out of my wheelhouse, but I went and read the cases and looked at the statutes and managed to deal with those matters. And I feel confident that anything that gets placed before me that is maybe something that I haven't previously dealt with, I can deal with it. I wrote a judgment that dealt with business rescue proceedings in terms of the Companies Act, and I, in my practice, never been involved in a business rescue matter. But I read the case law and I did the research and I was able to deal with it. So I'm confident that I can handle anything that comes my way. And if I myself can't handle it, then there's lots of other judges that I can discuss the problem with and get advice, because I do that quite often. You've got lots of legal minds there that needs to be tapped when you need someone to bounce ideas off and get some advice from.
Okay. Did you receive any?
May I ask you, AJP, to raise your voice to speak up?
Sorry. Did you receive any aspirant judges training?
Yes, I attended. Unfortunately, it was an online course in January because of the whole COVID situation, but I attended the aspirant judges course in January this year. It was pretty amazing. I'm just regretting that I couldn't attend the full course and attend in person so one could meet everyone and exchange ideas, but it was very, very educational. And the part that I enjoyed most was there was a lecture about judgments, because I thought, although I enjoy writing judgments, sometimes you have that writer's block where you just can't get that first paragraph down. And when I heard some of the judges, like I think it was Justice Matopo, explaining how he sometimes battled to start, I felt immediately at peace, because I then realized I'm not the only one and that it's a common problem, and that was quite enlightening, but it was very helpful.
So are you now satisfied that we are ready for permanent appointment?
Well, that's why I'm here. I feel that I'm ready, but I might be the only one.
Is there any specific skill that you'll bring with you to the bench?
Acting Judge President, I wouldn't say there's a specific skill. I think I've got a combination of skills that taken together would make me a good judge. I've got a lot of experience in litigation. I was a prosecutor for almost 5.5, 6 years. I've been in practice for almost 23 years. I've got the courage to go into court, and I've got the courage to tackle matters. And yes, I'm a hard worker. I've been phoned at 4 o'clock on a Friday afternoon and asked whether I could do an urgent application, hear it on Tuesday. They brought the papers to me on the Saturday morning, almost 1,000 pages, and I dealt with the matter. Those are the skills that I bring to the table. I've got the experience and I can work hard, and I've shown that I can produce what needs to be produced as a judge.
Okay. Lastly, if you are appointed, is it correct that you will be the first white female judge to be appointed in the Pietermaritzburg High Court?
Yes, as incredible as that sounds, because at the moment of the 13 judges in Pietermaritzburg, there is only 2 females, 2 black females. I'll be the first white female judge, and from our bar, the Pietermaritzburg bar, I'll be the first woman that's appointed to act in the High Court in Pietermaritzburg. So it will be historic, and it will be incredible. And the other ladies at the Pietermaritzburg bar is just 100% behind me and support me, and all wish to see this moment where someone from there, one of their own, can actually be a judge in Pietermaritzburg.
Okay. Thank you, Chief Justice.
Thank you, AJP. MEC?
Thank you so much, CJ. The first question, what is your understanding of the notion of transformation of the judiciary? And in the context of KwaZulu-Natal, what is it that people of KwaZulu-Natal should see such that they can conclude that indeed transformation of judiciary is happening to their benefit?
Thank you, MEC. I think if the ordinary man in the street looks at the bench in KwaZulu-Natal, if I look at the figures, there's 5 black men, 5 black females. I think there's 3 Indian males, there's 4 Indian females, 2 colored males, 1 colored female, 5 white men, 1 white female. It depends on obviously which member of the population, but it's got the appearance of quite a already transformed bench.
Am I correct to then say your understanding is confined to the changes in the demographics of the bench?
Well, the demographics, I think, are sorted out. If you want to hear me on whether the attitude of the judges on the bench, whether they have transformed and whether they are transformative judges, then I can say unequivocally yes. I have not come across a single judge that doesn't strive for transformation and doesn't hold those values dear to their hearts. That is the truth for every single judge that I've worked with, and I've worked with most of them.
What about access to justice?
That is always tricky because we all know it's a problem, because the ordinary man in the street cannot afford high court litigation. The ordinary man in the street, to get themselves to be represented in the High Court, would either have a very deep pocket or they would have to qualify for legal aid. And there's quite a gap, because you've got, if you want to apply for legal aid, there's like a ceiling. So, for instance, I'm not sure what it is. I'm a bit out of touch with that. But say, for instance, the ceiling is earnings of 5,000 Rand a month. So someone who earns 5,000 Rand or less would qualify for legal aid. But the person who earns, say, 15,000 Rand a month would not qualify for legal aid, but that person would still not be able to afford to pay for counsel to represent them in the High Court. And it's that middle group of people who do not have access to that type of justice. And I'm not even beginning to talk about the people in rural areas. I know our own acting judge president has written books about the systems out in the rural areas, the tribal courts and the tribal councils. There's lots of work still to be done to ensure that people out in the rural communities get access to justice. And it's a problem because it's a money issue, because there must be money available to ensure those people get access to justice.
Well, I see that we have not really featured or contributed in publications.
I assume that will be your last question,
Yes,
MEC?
yes, indeed.
Okay, all right.
CJ. Why is it so? Is it because of time, or you have found no value in making contributions to publications?
It's a time, and I've never thought that I've got the talent really to write things. I would concentrate my efforts on the people that I work with, people at the bar, and yes, that's where my contributions are, not in putting pen on paper, unless it's in a judgment.
Thank you, MEC. Commissioners, Commissioner Moimang.
Thank you, Chief Justice. Advocate Besserenhout, just make me understand how did you get around the argument raised around the legality principle and the rationality as components of the rule of law as it was raised in the TAIL South Africa against the National Director of Prosecution.
Yeah, Commissioner, in that matter, it was actually a very simple question that had to be decided, and that was simply whether there was reasonable and probable cause for the NDPP to sign that certificate. We obviously had to investigate and look from the papers whether they contravened the principles of legality, but bearing in mind the amount of information that was placed before the NDPPs, well, the first one and the second one, it was actually quite, I don't want to say easy, but it was, yeah, well, it was easy to determine that they had sufficient information before them to make that decision. It was not our job to decide whether there was a prima facie case or whether someone was guilty or not guilty. We simply had to look at what was the information that was before that person before he made the decision to sign that certificate. And we concluded that there was sufficient information, and that's on the basis that I made the finding that I did, that was supported by the other two judges.
Thank you, Advocate. Thank you, Chief Justice. Very crisp.
Thank you, Commissioner Moimang. I commend you for one question. Commissioner Singh.
Thank you, Chief Justice. I'm going to follow Commissioner Moimang. Good afternoon, Advocate Besserenhout.
Good afternoon, Commissioner.
Just one question. How familiar are you with the existence of traditional courts in KwaZulu-Natal, and what do you think about their role and efficacy?
Commissioner Singh, I haven't been to one. I know there's lots of traditional councils. Traditional courts have got their role to play because they can hear certain criminal and civil matters. The problem there, and maybe it's just for me a problem, is that obviously to keep the process simple and uncomplicated, they don't allow legal representation. I think someone who go and appear in front of a traditional court can maybe take a family member or someone else to represent them, but they're not allowed legal representation, which sort of offends against my feeling of everyone is entitled to have some type of representation when they appear in a court situation. But like I say, if they're there to deal with very simple and straightforward disputes, and they could play a role, because that could relieve some of the burdens that's on the district courts and the regional courts in our areas. But yes, I haven't been there, but it's certainly something that needs to be looked at, and maybe more resources put in to make those traditional courts function in a better way, to relieve some of the burden on the magistrates' court.
Thank you very much, Chief Justice. Thank you, Advocate.
I commend you, Commissioner. Let me go to the commissioners who are attending virtually. Commissioners attending virtually, is there anyone who has a question that they feel is important and they want to put to the candidate?
I have no questions. Thank you, Chief Justice.
Thank you, Commissioner Breitenberg. Yes, Commissioner Shabangu Mdawe.
Thanks, CJ. I want to follow up in the question that was asked by the MEC with regard to a transformation, and which issue was also raised by the advocate for transformation, where they indicated that they don't know any involvement of advocate.
You may follow up, but that will count as your question, okay?
Yes.
Follow up.
My question. Yes.
All right.
I want to know, advocate, how many young Black advocates have you empowered when you were still practicing, and you are still practicing?
Thank you, Commissioner. I must confess, when I read that comment in the OFT report, I felt almost saddened, because I've been involved in the lecturing and mentoring of pupils for the last few years. I've been on the pupillage committee since 2016, and I've played a very active role in the bar over many years, and it's a passion of mine to lecture pupils, to teach them, to keep on mentoring them after they've gone through pupillage and they started practice. One of the young Black advocates last year, when he had to start commencing his practice in, I think, January or February of the year, he didn't have chambers, because not in our building or in one of the other buildings was there any office space available for him. And I made my office available. He practiced in my chambers for almost 2 months while I was acting on the bench. I've had young advocates, they become almost my children. I've lectured them in civil trials for the last 3-4 years. Once I finished lecturing them, because we spend quite a bit of time together, I normally would lecture them on a Monday. I would see them through the week. We would have some time together, 3-4 hours before the exams, before the mock exams, the real trial exams. And they become very close to me. And they phone me at odd hours of the day or night asking for advice. People that I lectured 2-3 years ago still phone me for advice. Even now that I've been acting, if they come to see another judge and they see I'm there, they quickly come and they sit and they come and greet me and ask me how things are going, and quickly, while they're there, work in some quick advice to try and get a tip for a brief they're struggling with. So it's to me, yeah, I'm saddened by that remark that they were not sure what I've done for transformation, because I've been actively involved in the bar with the young generation of people that come into the bar, Black advocates, males, females, yeah, all the junior members of the bar. I'm passionate about advocacy training, and I'm constantly busy trying to teach people. Even in one of my first or second criminal trials, there were a lot of young practitioners who were appearing on legal aid, and I assisted them when they were cross-examining the witnesses. I cannot pass up a teachable moment, and I'm constantly involved with the junior bar and the junior members. So yes, that's.
Okay.
I've been very involved in transformation.
Thank you.
Thank you, Advocate.
Thank you.
CJ.
Thank you, Commissioner. Try for crisp answers, Advocate Breitenberg.
Sorry, Chief Justice, I'm going to try my best.
There is nobody among the commissioners, there's nobody else among the commissioners attending virtually who wishes to say something, to put
I
a
would like
question.
to pose a short question, Chief Justice.
You have a short question?
Yes.
Okay, all right.
Okay. Thank you, Advocate Besaidn't. You don't have to refer to it, but in the bundle, there's the Lesier versus Stainton case, and in paragraph 141, you may just make the point that caveat subscriptor, you know, beware he who signs, or let the signer beware, is still part of our law. And then you refer to, in a footnote, to the very old authority, and it is a classical authority, George versus Fairmead, which approves of a 1903 case. Did it not occur to you in doing the judgment perhaps to refer, I mean, there's been such a lot of development around caveat subscriptor and discussion of it in more recent case law, etc. So did you consider that, and did you consider the constitutional impact or the constitutional effect on the beware he who signs rule?
Thank you, Mr. Commissioner. I must say that was not even remotely the main focus of the judgment and the issues I had to deal with. That was just a very small thing that I added in, and yeah, I could have expanded on that, but I didn't think it was necessary, and I just quoted the most classic case, and yes, you're right, I could have expanded on that, but I didn't. But that case, I might just mention, after completing my form and submitting my application, a few days later, it came to my knowledge that the defendant in that matter, although I refused leave to appeal, he then applied for special leave to the Supreme Court of Appeal, and that was refused. And the defendant again asked for a reconsideration, and that I heard last week was also refused by the SCA.
Thank you. And I don't have a problem with the finding of the judgment, but my question really relates to the fact that when one quotes authority and so on, that one also has regard to a bit more updated authority.
Understand that. I'll take your point.
Yeah, okay.
Thank you, Chief Justice.
Thank you, Commissioner Barnard. Commissioner Pillay. As things stand, it looks like she will be the last one. Oh, there will be Commissioner Schlemmer. Okay. Commissioner Pillay for now.
Thank you, Chief Justice. Good afternoon, Ms. Besaidn't.
Good afternoon.
May I refer you to your judgment of State versus Como? It's at paginated page 92 of the bundle. Now, this was a case, it was a criminal matter involving an accused who, on multiple occasions, stabbed a woman multiple times until she died. Mm-hmm. You recall the case?
Yes, he pleaded guilty in front of me.
Yes.
Yes.
So,
oh, sorry, I don't think I've got the right. Sorry, page?
It's paginated page 90. If you can go to 96 for now, just to shorten the question.
Yeah, my numbers are a bit different, but
That's
I'll
fine.
find the decision.
If you can go to paragraph 39.
Okay, that's going to help me. I'm with you.
All right, so in paragraph 39, you recognize that violence against women is being perpetrated on a daily basis, etc., and that it's a cause for concern. But then you do two things which I really want to question you about. The first is in paragraph 40, you say it is unclear if the accused attacked and murdered the deceased purely because she is a woman. And that's the first thing I find of concern. I'm not sure what kind of evidence you were looking for to suggest that he attacked her because she was a woman. And secondly, on the next page, at paragraph 50, sub C, when you're considering additional factors, you say, I've also taken into account the following additional factors: the fact that the accused and the deceased were not involved in a relationship, and there was accordingly no emotional bond between them that could possibly explain the accused's violent reactions towards the deceased. So you seem to imply that if there was an emotional bond between them through a relationship, etc., that would account for and explain the violence against her.
Well, thank you. That is more to look at, because he wasn't forthcoming to explain what it is that set him off to be so incredibly violent towards this woman. If he had come and said she was his girlfriend, for instance, and he found out that she had been unfaithful, then that strong reaction would maybe go to explain why there would be such a vicious reaction from him. It's in no way meant to suggest that I would have accepted that as some type of excuse. I'm trying to find a reason for why it was a vicious attack. If you look at the medical records, it was just incredible. And I was trying to find some reason as to why he responded in that way, especially in light of the fact that nothing was forthcoming from the accused himself. If you understand what I'm trying to say. If it's a jealous rage because there was a relationship between them, there would maybe be some understanding, not an excuse, some understanding.
I'm sorry to say I don't understand, but I'll stick to the one question rule. Thank you. Thank you, Chief Justice.
Sorry, I couldn't answer your question. Sorry.
Well, I can assure you, Commissioner Pillay, that I do appreciate that when you put questions or anybody puts questions in relation to a judgment, one question might make it difficult. So I'm alive to it. But so I think in the past I would allow a little bit, because sometimes it's difficult to just put one question in relation to a judgment. But I encourage you and everybody to do the best you can. Okay,
I'm nothing if not compliant, Chief Justice, so I will comply. Thanks.
Commissioner Schlemmer.
Thank you, Chief Justice. Good afternoon, ma'am. I would just like to know, you said in response to a question by one of the commissioners that you don't let any opportunity to teach pass, and that is why when some of the junior counsel in court cross-examines, then you assist them. Now, my question is, do you assist them whilst you are on the bench, or do you assist them while you are just generally also counsel in court? Because I just want to be certain, to what extent do you teach whilst you are on the bench, or am I misunderstanding?
I certainly do not teach while I'm on the bench. After the completion of the case and when the matter was finished, they all came to greet me in chambers. And I couldn't resist the opportunity to hand to them a very good article written in, I think it's our Advocate magazine, that was written by one of the judges in our division on cross-examination. So I handed it to them because there were 2 or 3 of them that were very young, but I could see had quite a lot of potential, and they just needed the right article to read to push them in the right direction and help them for future. But I certainly would not interfere in court unless one of them would perhaps be on the verge of opening a can of worms when they were putting something to a witness that would be to the detriment of their client. But yes, I'm definitely not teaching when I'm on the bench.
Thank you. That allays my fear.
Thank you.
Thank you, Commissioner Schlemmer. I think we have come to the end of this interview. Thank you very much, Advocate Bezuidenhout, for making yourself available. In case there are 2 or 3 points that you would like to emphasize to the commissioners as points that you would like them to specially bear in mind as they consider your candidature, I give you 3 minutes to address those points. But if you feel that all issues have been adequately addressed, that will be fine as well.
Chief Justice, I'm going to not make use of that time because I know I've got quite a few colleagues waiting in the wings that's anxious to get their interviews on the go, so I'm not going to take that time. I'm simply going to say that my belief is that I'm ready and that I've got enough experience and that I will be able to do this job, and that's all I'm going to say because I know there's still lots to come after me. Thank you so much, and thank you for the opportunity.
Thank you very much, and you are now excused.
Thank you, Chief Justice.
Thank you. The next candidate can be brought in. Good afternoon, Mr. Gani.
Good afternoon, Chief Justice. Good afternoon, Commissioners.
How are you this afternoon?
I'm well, thank you, Chief Justice.
Thank you, thank you. We are all fine. We apologize that you have had to wait quite a bit for your time to come in. But if we could have done quicker what we were busy with, we would have, but we couldn't. I'm going to put certain questions to you, and when I'm done, I'll ask the acting judge president to do the same, and then I will allow, after that, the MEC who represents the Premier, and thereafter it will be the commissioners who will get a chance to put questions to you if they have some questions.
Thank you, Chief Justice. I understand.
Yes, everybody will put questions to you with a view to seeing how your appointment would meet the selection criteria that this commission has approved if you were appointed. So I will start by looking at your academic qualifications. I see that you hold 3 degrees. It's a BCom degree and a LLB and a master's in law, which you obtained cum laude, is that right?
That's correct, Chief Justice.
And you obtained all these 3 degrees from the University of KwaZulu-Natal.
That's correct, Chief Justice.
Your BCom you got in 1996, LLB in 1998, and then LLM you completed it in 2003.
That's right, Chief Justice.
Is that all right?
That's correct.
And you were admitted as an advocate in 1999?
In July 1999. That's right, Chief Justice.
Yes.
Sorry, April of 1999.
Yes. And then you started practicing as an advocate then, and you continue to practice as such.
That's right.
Okay. And you took silk in August of 2019?
That's correct, Chief Justice.
Yes. But I see that you also lectured part-time at the University of KwaZulu-Natal between 2003 and 2008.
That's right. I was a part-time lecturer in corporate law.
Yes. Okay. So that's the fact that you admitted in 1999, July, would mean that you have been in practice for about, what, 21, 22 years?
It's 22 years, almost 23.
Almost 23. Okay. Tell us about your practice over the years.
Yes.
What types of cases have you been doing, and what branches of law would the cases you have been doing in your practice fall under?
Yes, Chief Justice. As I tried to explain in the questionnaire, my practice fell into what I could call a few phases. I came straight from university. So over the first 2 to 3 years, it was a case of taking whatever work one could get. And over those years, I did criminal law for the Legal Aid Board, matrimonial work, motion court work, and so forth. Around about 2003 or so, my practice changed slightly, and that was for 2 reasons. One was I began lecturing, and the other was I was invited to join a group in Durban. The suggestion was that there was a need for young juniors in Durban. I took up both those opportunities, and from thenceforth, my practice began to change. Because I was lecturing, I began to receive more corporate law work, tax work, commercial work, and from Durban, I received quite a few junior briefs. That went on till about 2010 or so. And by that stage, my practice had reached the stage of what I could call senior junior. And principally, my principal areas of practice now, as they were from 2010 to 2012 or so, are constitutional and administrative, pension law, and corporate law. That's where it was when I applied for Silk, and that's where it is now, Chief Justice.
So it's a variety of branches of law.
Yes, there's certain branches of law I don't get briefed in.
Yeah.
For instance, matrimonial law or criminal law.
Yeah.
But for the rest of it, it's civil, focused on those 4 or 5 areas that I've described.
Yes. And you have, are there cases in which you have appeared as counsel which have resulted in reported case judgments?
That's correct, Chief Justice. I've put a few of them in the application, and there's certain of them in my CV as well.
Yes. And how long have you acted as a judge in the High Court in KZN? If you put together all the acting stints, to what period would they more or less come?
They come to 7 sessions. The sessions vary between 4 to 6 weeks. So that would be 7 sessions would roughly be about 35 weeks or so, somewhere there.
Yeah, about 35 weeks or so. Okay, and when you have been acting, what kind of branches of law have you dealt with in the cases that have come before you?
Yes. Chief Justice, in the civil sessions, one would do opposed motions, the motion court, civil trials, criminal appeals. There were lots of criminal appeals, urgent matters. And then I did 1 full criminal session, which involved a criminal trial from the start. That's the entire trial, conviction, sentencing, and in that session, criminal appeals and bail appeals. So it was probably the full range of what would be expected from a judge that would be a permanent judge over those 7 sessions.
Have you sat in full bench appeals as an acting judge?
I did. In fact, I sat in one last month as a civil full bench appeal, full court appeal, in which I wrote the judgment.
And how much motion court have you done, both opposed and unopposed, in terms of weeks?
A lot, Chief Justice.
Yeah.
In a session of, say, 4 to 5 weeks, an acting judge would probably get roughly 4 motion court sessions. So for each civil session, I would say on the average 3 to 4 motion court sessions.
In terms of your judgments as an acting judge, are there judgments you have written that have been reported?
I have marked 2 judgments as reported. Chief Justice, those are the 2 that I've attached to the questionnaire. For the rest of them, some may have featured on SAFLI, but I haven't marked any others as reportable.
Yeah. About how many written judgments have you produced as an acting judge up to now?
Chief Justice, I did a rough tally. If one had to include the extempore judgments, the written judgments, and reasons that were given after an order were given, they would be in the region of 40 judgments.
Yes. What do you understand by the rule of law?
The rule of law is the principle provided in Section 1C of the Constitution, which simply stated means everyone is subject to the law. The example that is given is that the president is, and as is the ordinary citizen.
And what is your understanding of the doctrine of separation of powers?
That is the principle that divides the arms of state, that is the executive, legislature, and the judiciary, into 3 categories, each of which has independence, and none of which can intrude upon the territory of the other. Simply put, from a judicial point of view, judges can't make law because that is the domain of the legislature, nor can judges get involved in matters of policy because that is the domain of the executive.
And what is your understanding of the independence of the judiciary?
Yes. Judges are subject to the Constitution. They take an allegiance or swear allegiance to the Constitution only, which means that they must decide cases according to the law, regardless of who appears before them, the fearless application of the law.
I will now give the acting judge president the opportunity to put questions. I must say, Mr. Gani, that I appreciate that you seem to be quite crisp in your answers. So, acting judge president, I give you the opportunity to put questions to the candidate.
Thank you, Chief Justice. Mr. Gani,
Judge President.
do you regard education and training as an effective tool for a judge in the performance of his or her duties?
Judge President, I do participate in the judges training course as well. So judicial education is important.
So according to your view, what are the benefits of continuous training for a judge?
A variety of things, Judge President. The law is constantly changing. There may be new practice directives which judges may not be exposed to because the matters one get depends on, it's uncertain. Matters are set down and judges don't know what matters they're going to get. So if there's continuous education, certainly judges that have not encountered a particular aspect of a particular field can be educated about that, and that could assist when they do get matters in the future.
So you have acted for some time. Is that
I have,
correct?
Judge President.
So is there any area of law where you feel that you still need more exposure?
Judge President, on balance, my answer is that with my experience as a practitioner and with the experience that I've had over the 7 terms, respectfully, I think I would be able to handle any matter that may be allocated to me. From the sessions that I've done, I've only acted in 1 criminal session, and as you know from my application, I'm not briefed regularly in criminal matters. But even that said, for the 1 criminal session that I have, I've produced the judgments and I've attached it. And my view, respectfully, is that I will be able to conduct any matter that may be allocated to me as a judge.
Okay, thank you, Chief Justice.
Thank you, AJP. MEC?
Thanks, CJ. First question. In the context of the independence of the judicial,
Yes.
do you think judges should accept invitations to address various platforms on topical issues in the public discourse, some of which may make a judge to express a particular opinion about a particular person or a particular policy position and still retain independence?
I think the first point would be that if a judge adopts or accepts that invitation, he or she should subscribe to what the Code of Conduct requires. I would be circumspect about what the judge should say. If a judge were delivering a lecture to a university, I would be inclined to say the judge should stick to matters of legal principle. Because even if the judge did not intend to intrude upon a policy aspect or an executive aspect, it can be perceived that he or she did so, and that can become controversial. So I have no difficulty with a judge addressing a particular audience, provided that there's compliance with the Code of Conduct, and the judge is circumspect about what is said.
Last one, SHA, having lectured part-time, as you indicated, but we have not really written for certain publications.
Yes, I lectured to the part-time law students, which was the evening lectures. So it was not part of that part-time post to produce articles or anything of that effect. The mandate or the employment was restricted to lecturing, setting the exam, externally moderating it, unlike a full-time lecturer.
Thanks, CJ.
Thank you, MEC. Commissioner Dodovu.
Thank you, CJ. Good afternoon. I want to follow the question that CJ asked you around the separation of power between different arms of government. What is do you know what judicial capture is? And if you do you see some elements of judicial capture in South Africa?
To deal firstly with the separation of powers, it's a separation of the arms of state. Government, to my understanding, refers to the government of the day, which is the executive, so to speak. You raised the question of judicial capture, you say. That is a difficult question. We know we have a body that's dealing with the issue at present. Findings will be made. Insofar as judicial capture is concerned, that would be a very strong allegation to make in relation to a particular judge. I recollect the former CJ making the point that if there's any allegation of judicial capture or any misconduct on the part of a judge, it should be reported. To my knowledge, and given the allegations that are in the public domain with respect to state capture, as we've experienced it or read about it in the last few years, I have not come across any credible complaint about a judge being involved as part of that, if I've understood your question correctly.
No, thank you very much. Asking on behalf of Honorable Nyambi, what about judicial overreach?
He's overreaching himself right now.
But Chief Justice, I was hoping I wasn't asked about judicial activism, because that might generate some controversy.
Yes, okay, thank you. Commissioner Singh, you had your hand up? Yeah.
Yes, very, very crisply, Chief Justice. Good afternoon, Advocate Ghani.
Good afternoon,
Just one, I see you've listed a number of referees in your CV. I take it all have been informed that their names are here on page 37.
Commissioner, the CV was updated over a period of time. For this particular round, for me being here, I must say I haven't called all of them. But previously, I have spoken to them about being a referee on my CV.
Okay, you've got 10 listed there. Some very influential people. My question will be, are you aware of the existence of traditional courts in KZN, and what do you think their particular role is, and how efficient do you think they are in performing those roles?
Commissioner, I must confess I'm not entirely familiar with the traditional courts. I haven't had any experience or exposure with relation to them in my practice or as a judge, but I understand their role. They have a vested role under the Constitution, as does customary law, common law, and religious practices, and so on. They're regulated by the Framework Act, which provides for kinship and the extent of it. And there's a section, I think, of the Black Administration Act, or two sections, which still apply. The nub of the matter is that there is a need for adjudication and for disputes revolving a traditional community to be dealt with by people from within that community. There are appeal rights, such as to the magistrates' court and so on. And ultimately, in a constitutional democracy such as ours, that can continue for as long as it does not clash with the provisions of the Constitution, including the Bill of Rights. That's as far as I can take the answer.
Thank you, Chief Justice. Thank you, advocates.
Thank you. I'm going to go to the commissioners. Commissioner Matolo Zlepu.
Thank you, Chief Justice. Now that you spoke about it, I'm going to ask you, what do you understand about judicial activism?
Well, I have trepidation about that because there is this trend about judicial activism, but my difficulty with it is that it suggests that judges can enter the terrain of their own views on public policy when deciding a case. And it goes back to separation of powers. If judges are to decide a case, they must do so subservient to the Constitution only. Where policy issues are introduced into a judge's decision, then in my view, it contravenes the separation of powers doctrine. That was my trepidation about judicial activism.
Okay, thank you, Chief Justice.
Thank you, Commissioner. I'm going to the commissioners who are attending virtually. Is there anyone who has a question for the candidate?
No question from Mr. Jane.
Thank you, Commissioner Shabangu Mdawe.
No questions from me, CJ.
Thank you, Commissioner Barnard.
I have a question, please, Chief Justice.
Please go ahead, Commissioner Breitenbach.
Thank you, Chief Justice. Good afternoon, sir.
Good afternoon.
Under what conditions do you consider apposite and appropriate to consider in a recusal application for a judge, and what would you consider as necessary for you to recuse yourself in a matter?
Sorry, Commissioner, could you please repeat that question?
What are the elements that you would consider necessary in order to recuse yourself in any particular matter, either on application or mere motu? Thank you.
You mean you said recuse yourself?
Yeah, recuse yourself.
Yes.
So the question is, what are the requirements for you to recuse yourself in a matter?
Yes. One would look at the Code of Conduct for Judges, which speaks about when judges could have an interest in the matter. So that would be the guiding principle. Constitutionally, judges are obliged to hear cases except where there's a valid reason to recuse himself or herself. I can give an example of how I've dealt with matters in which I perceive that there might be a conflict. In one particular case, I had acted for the respondent, and for the applicant, I had held a brief at that time that the matter came to me. I immediately sent off a directive to both sides, disclosing to them, making a full disclosure about the briefs that I held and the matter that I previously represented the respondent in, and invited them to advise as to whether they believed I was required to recuse myself. In that particular matter, both sides came back and says they raised no objection. They were aware of the previous representations and that I could continue. But that just illustrates that where there's a semblance of any party being unhappy or perceiving that you have an interest in the litigation, in the matter that you're hearing, a disclosure should be made. And that is how I see it, Chief Justice.
Thank you, sir. Thank you, Chief Justice.
Thank you, Commissioner.
Thank you. I have no further commissioners attending virtually wishing to say something, and I think it looks like we've come to the end of this interview. Thank you very much, Mr. Ghani. We appreciate your making yourself available for consideration. I'm going to give you 3 minutes in case there are points that you would like, 2 or 3 points that you would like the commissioners to particularly consider when they consider your candidature. But if you feel that all issues have been adequately addressed, that will be fine as well.
Chief Justice, permit me to take the 3 minutes, and I think I'll honor the 3 minutes.
Yes.
Just a few points I'd like to make so that my application is understood. Firstly, before I actually applied for the position, I conferred with the Judge President at the time and advised him of my intentions, and I received his blessing, so to speak. I also conferred with the Acting Judge President, and he was agreeable to that as well. All of the judges of the division with whom I have worked have lent their support to me. So I simply make the point that for those of the judges with whom I have engaged, they appear to support my appointment to the KZN bench. The second point, and this is just a matter for updating, as it were, one of the judgments that I have attached to the application, it's State versus Mtombeni. It's the first judgment in the pack. That was a criminal appeal. I simply point out to the Commission that since then there has been an amendment to the schedule. That's part 1 of Schedule 2 of the minimum sentence legislation. And the amendment takes into account precisely or substantially the issues of concern that we had raised in this full court, such as the rights of the victim. That's the second thing I point out to the Commission. I'd like to think that the judgment contributed to some aspect of the legislature considering the problem. And then thirdly, and this is just a matter in case it does feature, I see from one of the reports, it's the GCB, that makes reference to the composition of the KZN bench with respect to race and gender and so forth. And I make the point simply that if one looks at the composition, it comprises 10 black men, 5 white men, 3 Indian, and so forth. Respectfully, an appointment or recommendation of someone like me, an Indian male, would, as some of the reports say, not be contrary to transformation of the judiciary, and also be consistent, I think, with Section 1742, which deals with diversity. Those are my points, Chief Justice.
Thank you very much. You are now excused.
Thank you, Chief Justice. May I express my gratitude for the manner in which the interview was conducted.
Thank you.
Thank you. Take that one.
Yeah. No, long live the October spirit. You can bring in the next candidate. Good afternoon, Ms. Hiralal.
Good afternoon, Chief Justice.
Did I pronounce your surname correctly?
Yes, thank you.
Okay, thank you. How are you this afternoon?
Quite nervous, Chief Justice, but I'm sure I'll settle down.
No, you will be fine. The commissioners would like you to be comfortable as they ask you questions. I'm going to ask you some questions, after which I will allow the acting judge president to put questions to you, and thereafter the MEC who represents the premier. And after that, I will allow commissioners who might have questions for you to put their questions to you. I see that you hold the degrees BA Law and LLB. Is that right?
Yes, Chief Justice.
Both of which you obtained from the University of Durban-Westville.
Yes, that's correct.
And you obtained your BA Law in 1982. Is that right?
That's correct, Chief Justice.
And your LLB in 1984.
That's correct.
And you thereafter served articles with IC Mia Mutala and Company initially from May 1985 to May 1986, and thereafter you must have ceded your articles to Halse Havemann and Partners. Is that right?
That's correct, Chief Justice.
That was June 1986 to October 1987.
Yes, that's correct.
And you got admitted in 1987 and worked as a professional assistant at Halse Havemann.
That's correct, Chief Justice.
And later, that was in 1988, you joined as a partner, you joined Priscilla Jana, Hiralal, and Associates. So did you get into a partnership with Priscilla Jana?
Yes, that was very brief, Chief Justice.
Yes. And but why does it look like that partnership was short-lived? June 1988 to December 1988.
Yes, Chief Justice. Priscilla Jana was my paternal aunt, and we went into a partnership. Being my paternal aunt, well, actually, I didn't intend to start telling you about myself now, but I, in my life, have had 3 mothers.
Yeah.
And Priscilla Jana was one of them. And being in partnership with the two of us sometimes were at loggerheads, although we loved each other dearly. And we decided, she as well agreed that I should go my own way.
Yeah.
Although I still did the same work.
And then you became a sole practitioner from January 1989 to 1996.
That's good.
Is that right?
That's correct, Chief Justice.
After that, did you then focus on CCMA work?
Yes, Chief Justice.
Or not really?
No, it was industrial court in the 80s and early 90s.
You continued to practice beyond 1996 as an attorney?
No. I joined the industrial court in September 1995 while I was still in private practice.
Yes.
And then sold my practice in 96 and continued to do industrial court work until 99, 2000, when the backlog was completed.
Yeah.
And then I joined the CCMA in 99, 2000.
Yes. And when you joined the CCMA, did you become full-time at the CCMA?
No, Chief Justice.
You were
I've always
part-time.
been a part-time commissioner. Initially, I was a level A commissioner. 2006, I became a senior commissioner.
Yes. And at the CCMA, did you do both mediations, stroke conciliations, and arbitrations?
Yes, of course, Chief Justice.
And do you continue to be a commissioner at the CCMA?
Very much so, Chief Justice. That's where I'm going back next week.
Yes. So in terms of stopping to have a practice as an attorney, when did you stop?
I last practiced as a lawyer, appearing in courts in 1996.
Yes.
That's something that I need to address. I see advocates for transformation have commented on that.
But you emphasize that you last appeared in court in 1996, but did you continue to keep your practice even if you didn't appear in court, or did you stop your practice?
I sold my practice and I stopped practicing, but I remained with the Law Society, registered with the Law Society. And in 2015, when my children went into private practice, I joined them. That's when I joined them in the practice. But even then, I still don't do any court work. I don't do any appearances. I only deal with the arbitrations as part of the CCMA, my CCMA work, and my bargaining counsel and Tukiso work. So I deal with arbitrations other than my acting stints in the High Court and in the Labor Court.
Yes. Now, prior to 1996, or as at 1996, for how long had you practiced as an attorney? It's about 10 years?
Yes, Chief Justice. I opened my practice in June 1998 and then sold it in 1996. Prior to that, I did a little bit over 2 years of articles because I had registered it late. In that time, I did all the magistrates' court work that I had. I appeared in the magistrates' court, the industrial court, all of. I did some civil litigation, not a lot, ordinary small things, motor collisions, interlocutory applications in the magistrates' court. When I served articles with Mr. Mear's office, we were an agency for the Durban offices, so we did a lot of their collection matters and their application court. When I came to work for Hulse-Hoffman and Partners, that's where I got the most experience in civil litigation because, as you'll see from my CV, that firm and the department that I worked in was the civil litigation department, and they did a whole lot of insurance litigation. And if you recall, that was a time that PATCO was the main service provider, and the insurance companies were National Employers General, Santam, and South African Eagle, etc. So I did all of the preparation for trial at that time. Expert witness notices, consulting with counsel. All of the people that I consulted with are now some of them judges. So the preparation the experience that I got in the preparation there, Chief Justice, I believe holds me in good stead in my High Court work, because when the AFT says that I don't have sufficient civil litigation experience, it's not about appearing in court only, it's about knowing what goes into the case itself, all of the preparation beforehand, the discovery.
But are you saying that at that time, you didn't appear in court to conduct trials yourself, civil trials, and to argue applications, whether magistrates' court or High Court?
I did, Chief Justice. I did, with Hulse-Hoffman and Partners, with the magistrates' court work. I did appear in court in the criminal and civil trials. When I was in private practice, I appeared in court all the time in civil trials, criminal trials, a lot of criminal litigation. I did a lot of legal aid work. And I appeared in the industrial court. So I have no shortage of court appearance experience. The shortage comes from 1996 until now.
Or prior to 1996 or up to 1996, you say you did that?
Yes.
The time when you talk about being involved in preparation for trial but not going to court, Is that after 1996?
No, sorry, Chief Justice. That was when I was serving articles with House
Or when you were
and
serving
Partners,
articles?
and when I joined them shortly after my admission as an attorney, I did all of the preparation for trial because those trials were in the High Court. If you recall, in those days, attorneys did not appear in the High Court, so I prepared all of those trials and appeared in court with counsel and with the other attorneys from our office. But it was not my domain. The domain in which I appeared in court was a magistrate's court, civil litigation, the ordinary, like I said, motor collision, etc., but more criminal work, because I got so much of legal aid work, and in those days we called it fish and chips court. It was the interlocutory applications in the magistrate's court.
Yeah, okay. You said you also sat as a presiding officer in the old industrial court as well?
Yes, Chief Justice.
For how long did you do that?
For 5 years.
That's from what, 1990?
1996 until 2000.
Oh, okay.
By then, the Labor Relations Act was now defunct, but there was a backlog, and that's the work that I finished up and then moved on to the CCMA.
Yeah, okay, all right. And so in the CCMA, you have been a commissioner since around about when?
1999.
1999. So that's about 22 years?
Yes, Chief Justice.
Yes. And you have done arbitrations. You have done a lot of arbitrations.
Mediations, and conciliations.
Okay. Do you have an idea about how many written arbitration awards you have done, recent arbitration awards?
Chief Justice, they must run into hundreds, a few hundred at least.
Yeah.
Because as much as I'm a mediator, conciliator in the CCMA as well,
yes,
I'm often called on as a senior commissioner and with my experience to do the hard cases.
Yes.
And the long cases.
Yes. In the High Court, you have acted for how long if you put all the periods together?
I added up the High Court and the Labor Court, and it comes to 60 weeks.
16?
60.
60?
Yeah, and yes.
Okay, let's talk about the High Court only for now. How many weeks have you acted in the High Court, if you are able to say?
So that would make it 50.
50?
Yeah, 49 or 50.
Or you have acted more in the High Court than in the Labor Court?
Yes, Chief Justice.
Oh, okay. I would have thought that you would act more in the Labor Court because it looks like most of your time over the past 22 years or so has been devoted largely to labor work, because you said you have been a CCMA commissioner all these years.
That's correct, Chief Justice, but I'm an attorney and a lawyer at heart.
Yes.
And I've always wanted to do the work that I'm doing at the moment. Civil litigation came to me very easily when I returned in 2017 to act in the High Court.
Yes. Are there any cases in which you were an instructing attorney up to 1996 which have been reported?
No, Chief Justice, I don't think there are. But the people that I briefed in those days were a former JP from KZN, Chiman Patel, Advocate Vas Soni, Sachi Kavanda, who's now emigrated. There was a female advocate, Adharam Singh.
Yeah, no, that's fine. I just wanted the reported judgments. What is your understanding of the rule of law?
Chief Justice, I'm thinking how to formulate this crisply, as you would say. the Constitution, we have a constitutional supremacy. But for me, I think that if we don't have the rule of law, then the Constitution would really be relegated to a piece of document. It's the rule of law, the principle, the founding principle of the rule of law that keeps our Constitution alive. And it's the judiciary that is the vehicle by which we keep our Constitution and our rule of law alive. It's the principle by which everybody is equal in the eyes of the law, and it's the only way we keep a social order and there's no chaos in our society.
Mm-hmm. And what is your understanding of the doctrine of the separation of powers?
Well, that keeps the three arms separate. That's where they should be, because you couldn't very well have the executive or the legislature dispensing justice. The judiciary is the entity that dispenses justice, and each entity should be on its own. There might come a time where I suppose the judiciary would have to comment or make judgments on issues that relate to other arms, but that would be where, I suppose, where you have disputes dealing with the separate organs of state. I recall the public protector's case where the court, the judgment did suggest that the judiciary should not step into that arena. So the three entities should be separate.
And what is your understanding of the independence of the judiciary?
That's of paramount importance, Chief Justice. That the judiciary has to be clean as a whistle, if I could say that. The judges have to dispense justice fearlessly, with independent mindedness, impartially, and it's the entity by which our Constitution and the rule of law is given effect. It's, I think, the most important arm between the three, because if you can't have a good judiciary, then the Constitution becomes meaningless, and how do you dispense law? How do you dispense justice?
I'm going to now afford the acting judge president the opportunity to put questions to you. Acting Judge President.
Thank you, Chief Justice. Mrs. Hirala. Good afternoon.
Good afternoon, Acting Judge President.
Yes, I will just ask you a few questions arising from the comments by various bodies. AFT is of the view that you lack adequate and necessary grasp of civil and commercial law. What's your view to that?
Acting Judge President, it's correct that I haven't had, and I've been upfront with the Commission that I haven't done any civil litigation or any court work since 1996 until 2017. But I've always been a lawyer. I studied law at the university. I practiced for, if you count my articles, in my private practice, I've practiced law for 10 years, civil litigation and criminal litigation. There are many years when I was away from the courts did not in any way alienate me from the law. The work that I do on a daily basis involves so many parts of the law. It's not just a CCMA arbitration that a CCMA commissioner does. There are various principles of the law that would come in, and very often we are required to deal with the law of evidence, different principles, and in many ways as well, arbitrations are very much like civil trials. It's just a matter of the principles that are being utilized in the different processes. In addition to that, in arbitrations, you get a wide variety of the kind of disputes that you deal with. In a misconduct arbitration, you'll deal with procurement, offenses during procurement, assaults, theft, dishonesty. So you're called on to draw from the different fields of law in your CCMA work. So I don't see that that in any way makes me not suitable for the judiciary. I think that if there is a shortcoming in that regard, then the Commission must look at the fact that I have many, many years of adjudication experience and arbitration experience, mediation experience, which is so important. It's all good to be a judge who's going to sit and listen to cases and then write a judgment, because what I do see often in the High Court is that people come to court saying, I want a judgment. And I actually heard that phrase when I was sitting in a full court appeal with 2 senior judges, where somebody said, senior counsel said, what we want is a judgment. But many disputes can be mediated. And surprising as it may sound, the judiciary can learn a lot from an organization like the CCMA, where we have conciliations and arbitrations. A commissioner, whether you are junior or senior, makes a very big effort to try and resolve a dispute before going into arbitration. One would ask, well, in court, how do you make use of something like that? Don't you suddenly land up with a tainted mind and then you can't deal with your trial? No, if you're skilled and you deal with your mediation attempt properly, you can still deal with your matter thereafter. So there is room, Acting Judge President, for mediation in the High Court. So my skills, in as much as I've been away from civil litigation, I do bring that kind of skill and my many years of experience in handling parties. I don't have a difficulty with command of the courtroom and control of the courtroom. None of that phases me. I'm very much in control. I have a personality which is resolute. I think I'm steering off the topic here, but I have an independent mind. I'm highly regarded in my profession, in my field.
May I remind you to please be crisp, Ms. Hiralal?
Thank you, Chief Justice.
Yes.
I realize that I'm steering off the path. But my shortcomings in a short answer, my shortcomings in civil litigation should not be held against me. I come with a vast amount of experience in other fields, as I've said. And
I thought you have really answered the question, Ms. Hiralal.
Thank you.
Yes. Okay, continue. AJP?
In your view, do you still need any exposure before you're considered for permanent appointment?
No, I don't think so, Acting Judge President. I'll tell you why. The cases that I chose when I submitted my application, I had in mind to show the Commission the kind of person and the kind of work that I do that involves social justice and social issues. And that is why I put in a certain kind of judgments for you to read or to see what work I do. But when I looked, I was looking last night through the kind of work that I've done in the High Court. I've done commercial contracts, disputes. I've done, and I just prepared this last night. If you'll just let me look at it, Chief Justice. Anton Pillar orders, one Anton Pillar order, commercial contracts, one involving the Islamic law, liquidations, sequestrations, perfection of a notarial bond. But each one was not a simple dispute. It involved several principles. search and seizure, unlawful arrest, spoliation orders, contractual, I said that, procurement disputes, which also was contractual. So although I haven't had the experience, I have the means and I have the ability to research. I know where to find the law, and that's what I did. When I first came in 2017 to ACT, that's what I had to do. I had to research, and I'm industrious. I can go by 3 or 4 hours of sleep a night to make sure that I have my work ready and I'm prepared. There was something else I wanted to say, which I forgot.
You have listed 19 judgments outstanding.
Yes, Acting Judge President. I'd like to explain that.
How, yes.
Just a little bit of background. In the CCMA, the kind of work that we do is demanding in terms of time. When you finish an arbitration, whether it was a one-day arbitration or for over 40 days arbitrations like I've done, you have 10 days in which to issue your award. If you ask for an extension, you get only 7 days more, and that is it. You have to get it out. That's the legislative requirement. And I have never, ever issued an award late. I pride myself on timekeeping, being industrious, like I said, and working very hard. When I was in the High Court, the entire time I never had late judgments. The Labor Court is where I wanted to go and get some more experience. And those judgments that you see in the list came from 8 weeks of work. 8 weeks of work gave me that number of reserve judgments. You have to take into account that the roll for the week had about, well, let's talk about the motion court for Labor Court. Every week on a Friday had between 20 and 25 cases, which I prepared for and handled, and a lot of them were opposed on that roll. But from Monday to Thursday, I dealt with reviews, and they were opposed reviews and other opposed applications. If you've seen a review file from the CCMA, it comes to you in a box with lever arch files of records. I did those every day for 8 weeks, for the 8 weeks that I was there. And unfortunately, I couldn't keep up with reading the records. There were some cases, sometimes 1 or 2 cases per day. So I accumulated these judgments from 8 weeks of work in the Labor Court. I spoke to the Judge President, Judge Wagley, and he was very sympathetic to me on this. And he apologized to me to say that he didn't realize that this was how it's going, how busy it was. And in addition to that work, the reviews and the motion court, in the afternoon, I would get a call at 3 o'clock or 4 o'clock for urgence, which required an order by the next morning. I was able to overnight have a written judgment out for the next morning for complex urgent opposeds. So when I was filling my application for this post, it was very painful for me to write that I had so many judgments outstanding because it would be a poor reflection on my work ethic. But, and of course it was picked up by LSSA. But I do have a good explanation for it. It was a very, very busy court. There were only 2 judges. That was my load of work. The other judge had her own load of work. And that's what happened.
Mr. Sherrod, are those judgments still outstanding?
Out of all of them, I've got 3 left, which I've spoken to Judge Wagley, and he's quite happy for me to hand them down within the next 2 weeks. But again, I must explain that while I was handing down those judgments, I've been busy in the High Court in January in a criminal trial with 67 witnesses. I managed to complete the trial, but judgment is going to be handed down in July. We finished the evidence on the last day, probably in the last hour. And then I did motion court, civil court for the last session that I was in the High Court. And I've picked up a few reserved judgments from there, but I also handed down extemporaries in appeals and in my motion court matters.
So, would you agree with the statement by LSA that you, in the light of these judgments, we are not ready for permanent appointment?
Definitely, I don't agree with that, Acting Judge President, because I've just explained how my work ethic, if I have to present something by tomorrow morning, I will stay awake tonight to have it out. Those judgments, there's a special explanation for that, and it is the first time in my life that I was faced with that situation because of the work that came so fast and furious.
Okay. In the High Court, do you have any outstanding judgment?
I've got 4 opposed motions and 1 trial judgment and 1 appeal, but I've handed down the rest.
So how old are those?
It's from the session that we just finished last week, the week before last.
They are not older than 3 months.
No, Acting Judge President, and they are all in various stages of finalization, because when you go into an opposed motion, you've got your judgment 3/4 written because you've looked at the heads of argument of both parties and you've researched everything. It's just that last bit that, just to finalize it and just to tidy it up.
Okay, you just alluded to that the skill you are bringing with you to the bench is the conflict resolution skill.
Yes, Acting Judge President.
And also the GCB also has indicated that you have also a social and administrative justice skill.
Yes, Acting Judge President.
Lastly, it is stated that your appointment will enhance the gender representativity in the bench. Do you agree with that?
I agree with that, Acting Judge President.
So do you know, maybe you can explain how that appointment achieve that purpose?
In terms of gender representativity?
Yes.
Well, I think the Pietermaritzburg court, I've counted, but I know that you have an Indian male, you don't have an Indian female in Pietermaritzburg. You don't have a white female either.